number 12, the people of the state of New York versus Fernando Maldonado. Counsel?
Good afternoon, Your Honors, and may it please this Court, Louis O'Neill with White & Case, pro bono for Mr. Maldonado, together with co-counsel Legal Aid Society. I'd request 3 minutes on rebuttal, Your Honor.
3, sir?
3.
3.
It's a curious case where the defendant obtained nothing, either title, nor possession, nor any money to the property in question.
How could this not be at least a purported transfer?
I'm glad.
What is a purported transfer if it's not this?
So a purported transfer deals with a voidable deed, a deed that can be undone. It's a deed obtained by trickery. I trick someone into signing his name to the deed, and I file it.
And why isn't this a voidable deed?
It's not a voidable deed because it's akin, as Justice Rivera said in Faison v. Lewis, it's akin to a forged deed. It's a spurious and powerless paper. It's a void paper.
That's a real property case and a real property term. This is a criminal statute. So it says purported transfer. As I understand your argument, it would leave nothing but a transfer because you're saying obtain title in a voidable case. Title's good if it's sold to a third party, which is, I think, the gist of those cases. So purported transfer has a meaning in the criminal larceny statute. And if this isn't a purported transfer, I don't know what would be.
Well, Your Honor, I would respectfully disagree. There's no...
And a second follow-on when you're answering is, was this void versus voidable issue raised below in the trial court?
Absolutely it was, Your Honor. This is preserved completely in 3 or 4 places. And in fact, the people brought over an appeals assistant to argue it. It was ruled upon. It's clearly preserved on this question. As to why this is not a purported transfer, there is absolutely no evidence support in the criminal law. And by the way, this court's job is to harmonize the law across the state. And where else would we look but to real property law when a deed is in question or a forgery is in question?
But the real property law has nothing to do with a purported transfer under the criminal statute. It means something.
Right.
There's no indication anywhere that it means void versus voidable deed under the real property law. So it has to mean something other than obtain title, which seems to be the gist of your argument.
If it means what you're suggesting, Your Honor, then you can file any paper and obtain anything. As this court said in Dorothy v. Martin.
Which I think is also a real property case.
It is, but it has criminal elements to it.
I don't understand that argument either, because here it wasn't as if he walked in and said, I own the Empire State Building. He had property tax records, he had produced all these other records. He filed this quitclaim deed, which shows up in the real property system. He's the purported owner in that real property system if you go and log on. So I don't really see the analogy to I walk in and I just say I own the Empire State Building.
Well, that's what he did. He said, I own this building, and it applies.
Oh, he filed a quitclaim deed.
He did.
That then shows up in the official system saying he's at least partly a record owner.
Which would happen with any property that anyone tried to claim.
There's testimony that the actual owner would have to go through a legal proceeding to get that deed off the records.
A civil proceeding, again, not a criminal, to Judge Garcia's point, not a criminal proceeding at all. Again, you can't bring the full weight.
But it still goes, but the point is, and you say this is not a voidable deed, but it's a deed that is on record in the county clerk's office, and if someone wanted to rely on that deed, they could, unless the owners went and said, wait a minute, this is a mistake, what do we have to do? And they would have to get it undone. Why isn't that the same thing as being voidable?
Because it's an enormous leap from doing that to taking possession or control or title to a building.
Yeah,
but that's obtaining
the statute
title.
Has 2 things. It says obtaining title or purported transfer. So
it's a nullity. As Justice Rivera pointed out, it's a nullity. It doesn't exist. A forged or deed akin to a forgery under Faison v. Lewis, 2013, in this court, it doesn't exist.
It doesn't have an
power.
effect of transferring legal title as the other type of voidable deed would have if a third party buys it. But it is not a nullity, I think, as Judge Stein was pointing out, because it has real effects. It has real effects on the property owner under property law. But on the ownership interest of these on the condo owners, They have a cloud on their title. They can't mortgage. They can't sell without relieving that cloud. And they have to go through a civil proceeding to do that. So that, it seems, is the problem we're having with your definition of purported title is just solely a real property term that goes to whether or not an innocent third-party purchaser actually obtains title.
Let's look then at the history of purported transfer, where it comes from, the Model Penal Code. In 1954, in May, in the draft of the Model Penal Code, that word was not there. It continued to not be there in 1955, in May. It appears in May 1962 in the draft, and the commentary is this is a minor verbal change, the addition of purported. There's no way that...
But it has to have some meaning.
Certainly, it means that this is a voidable deed. A voidable deed is a purported deed. I have transferred, through trickery, my property to you. It's an actual transfer under Tremato. This case is a decision in 1993. And it can be undone.
Where does it say that?
Tremato stands for the proposition that you must transfer either title or possession
I know, I
to steal real
understand.
property.
Where does the penal law say that the intention was only to prevent obtaining title by trickery?
The penal law is silent on the definition of purported, which is why the rule of lenity is so important here. People v. Gulp. When there's confusion about what something means, the tie goes to the defendant, not the people. And our definition, our suggestion is more plausible than the people's. They have no support for their definition.
Counsel, I'm sorry, your light is on there on the warning light, but could you address the reliance issue on the false pretenses?
Absolutely. It's black letter law that to steal property under a theory of false pretenses, the owner of the property must rely on the false pretenses, not some third party, not the registry, not anyone else. It's the owner. And here, so many things happened where the people proved the opposite, that no one was relying on this. No one believed that Mr. Maldonado owned the building. Anytime anything he did, the water bill, the stop work order, the mail delivery,
Didn't
it
the
changed it back.
financiers, HFDC, HDFC, and what's the other one, MDC, didn't they rely on it?
They're not the owner of the building.
Yeah, that's
They're not the
true.
owner. It's black letter law. The owner must rely on the property.
And-
Chayton, Tremato.
That would be an ineffective claim here.
This is an ineffective, it's an element of the crime. It wasn't some appellate lawyer trying to find it. The defense lawyer himself said, oh my God, I made a mistake. Please call me ineffective. I missed an element of the crime. That's settled black law in this court. And the court wouldn't allow him to be removed.
Thank you, counsel. Counsel?
May it please the court, my name is Solomon Newbort. I represent the people. Good afternoon. This was a purported transfer.
Counsel, I don't mean to stop you, but just to follow up while we have this topic on the table on the reliance issue, it seems clear to me there is no reliance by the owner here.
Well, Your Honor, I would just point out that it's true that the label that the prosecutor gave to this theory was larceny by false pretenses, but in fact, as articulated, it never was the common law case of larceny by false pretenses.
Counsel, there's two problems with that to me. One is, I think under our case law, you have to choose a theory. You can't just charge Section 1 of the statute. And two, you chose this one not only as a theory in the courtroom, but as charged to the jury.
Actually, as charged to the jury, there was never any statement about reliance. The court says to the jury, to find the defendant guilty, you must find, the court speaks about the elements of larceny by false pretenses, but then says, in order to find the defendant guilty, here's what you got to do, and doesn't speak at all about...
I saw that, but then there's a note. First he says he gives that instruction, and he includes reliance. Then he says you have to find these elements. But then a note comes out, and in response to that note, he sends back in as the elements the reliance issue.
Again, he speaks about the elements of reliance, but then says, in order to find the defendant guilty, and again reiterates, here's what you have to find, and then again omits reliance. So for the jury, what they had to find was, the court says, here's the sum, and here's what you have to find, and says that there's no... In fact, the defense counsel is saying that there was ineffective assistance of counsel for failing to preserve this issue, but now you seem to be suggesting that, in fact, reliance was there, but it wasn't. And in fact, if you look at page...
Can I just slow down? So your argument is that we have to rely on the actual charge, not the charge that should have been given.
Correct.
Right, and that we're limited to that actual charge, and as a result of that, we can't get into the reliance issue, isn't that the
Correct.
core of
If
your
you look at
argument?
page 40 of my brief, you'll see a quotation of the actual charge as given. Plus, I would just point out, had
I'm
defense
sorry,
counsel...
counsel, before you leave this issue, you're saying the court gave the charge under the CJI?
The court ultimately said, here's
the-
what you have to find in order to find the defendant guilty.
No,
After
but-
giving the elements of the crime under the CJI, then says, okay, so bottom line.
Skipped over a line, Reliance.
Skips over reliance and says, here's what you got to find. You got to find that the defendant went into the county clerk, filed fraudulently, wrongfully filed a deed, and that he intended thereby to deprive the owners of their ownership, and that the value of the property was $1 million.
So
That's what the sum...
So was it ineffective for counsel?
No, and here's why. Because the label larceny by false pretenses was never discussed as the elements of the crime. It was relating to a different conversation. The defendant was trying to obtain a charge on claim of right, and on the affirmative defense of claim of right. And so the question became, are you, the prosecution, the court wanted to know, are you arguing that this was a classic case of larceny of dispossessing the owner of the physical possession? Are you saying that anyone was thrown out of their apartment? Or are you saying this was a title type of claim? And so the prosecutor said, yes, it's a larceny by false pretenses, but not talking about the elements. When asked, what is your theory of the case? What was the larceny? If you look at page 655, A655, here's what the prosecutor says. Walking into a clerk's office, a government office, and filing a deed in which you assert an ownership interest to the exclusion of the rightful owner, that is the completed larceny, Your Honor. So while they were talking about larceny by false pretenses, that was just to distinguish the case from a classical case of taking. Had the defendant objected and said, look, Your Honor, there is no reliance in this case, I move to dismiss, the prosecutor might very well have responded by saying, we called it larceny by false pretenses. It's really larceny by purported taking. There is no, you're not going to find in books
When
the
was this-
name
when-
larceny by purported taking.
When was this issue first raised in the 330 motion?
The
Post-trial?
defendant, yes, the reliance issue was first raised in the 330 motion.
So it
Had he
wasn't-
raised it at trial,
Slow down, so it wasn't preserved, that's your
Yes.
first argument. And your second argument is that the verdict has to conform to the actual charge, not the model charge.
correct. And as far as ineffective assistance of counsel, had he objected in a timely manner, the prosecutor presumably would have said, my theory again is that this is a larceny by purported taking throughout the trial, kept as articulating the theory.
Well, let me
it
ask
was
you this, if
larceny.
he had objected, would the court have to modify its instruction and include the reliance element in the charge?
No, because again, the people's theory as articulated really wasn't larceny by false pretenses, it was larceny by purported taking. And so you don't have to have any reliance, because it wasn't larceny by false pretenses.
But
They
that-
called it, they
I'm
gave it a
sorry,
label, a
counsel,
generic label.
That larceny by purported taking is section 1 of the larceny definition. But isn't it our case law that you can charge that in the indictment for pleading purposes?
Correct.
But in order to convict for larceny, you have to have one of the theories enunciated articulated in the second section of the statute.
No, it could be enunciated in the first subsection. The defendant was charged in the indictment only with larceny without a subsection.
Which is sufficient for pleading
Correct.
purposes, but not for conviction, as I read our case law.
Correct, but as articulated, the prosecutor throughout trial articulated the theory, putting aside the label, said again, and I read to you, when asked, what is your theory, the prosecutor says on page 655, and this is throughout the trial, walking into a clerk's office, a government office, and filing a deed in which you assert an ownership interest to the exclusion of the rightful owner, that is the completed larceny, Your Honor.
So which provision under subdivision 2 does that fall into?
No subdivision 1.
But you can't convict on subdivision 1.
You could convict under, I'm sorry, Your Honor. You can convict either under subdivision 1 or subdivision 2. There's the subdivision 2 only codifies some of the odder types of the common law forms of larceny, like larceny by trick, larceny by false promise, larceny by false pretenses. But the regular form of larceny of going over to somebody and stealing their wallet, taking their car, taking their bicycle, that is a subdivision 1 case, and essentially, as articulated by the people throughout the trial, putting aside the label, it was always that this was larceny by purported transfer. They gave it the wrong name, larceny by false pretenses, but no one was misled by it because the prosecutor throughout the trial kept saying what it was, and but for ineffective assistance purposes, had the defendant objected at trial, the people would have said, our theory is larceny by purported transfer, not larceny by false pretenses, and so he would have gained nothing by this.
So at trial, the prosecutor never said the theory was larceny by false pretenses.
Not
We
the-
will not find that anywhere in that transcript.
No, he says that they were talking about whether the defendant was entitled to a charge on the affirmative defense of claim of right, and so they said, are you talking about the classic case of dispossession, or are you talking about transfer of title? No, as you say, it's larceny by false pretenses, but when actually articulating what the theory is, not the name, he kept saying throughout, and then the appeals assistant came and kept saying throughout, this is larceny that's about a purported transfer. So the claim, the legal sufficiency claim is unpreserved. For ineffective assistance at counsel purposes, had the defendant objected and said, where's the reliance, they may have clarified and said, no, we called it larceny by false pretenses. In fact, no one was misled. It's really larceny
Okay,
by
so just
purported
to
transfer.
clarify, I'll try it again. There is nowhere in this transcript, you're in the trial, that the prosecutor said it's larceny by false pretenses. Nowhere to be found.
No, it is to be found. The court says, I think this is larceny by false pretenses. The prosecutor says, yes, but it was in the context of a affirmative offense, whether the affirmative defense of claim of right should be. But when asked, can you articulate how this larceny occurred? So again, for the final time,
Isn't that about
prosecutor says-
the unfolding of the events as opposed to your theory?
I'm sorry.
In that response, how did this occur? This is the events that constitute larceny by false pretenses?
No, Your
Is
Honor.
that what that response means?
No, I don't think so, Your Honor. I think it was just but again, this is an unpreserved claim, so it's only about ineffective
talking about
assistance
the
at
ineffective
counsel.
assistance of
So
counsel.
there's nothing preventing the people during trial to say, look, as it's unfolding, we misspoke and we called it larceny by false pretenses, and no one was misled by
Change
it.
our theory of the case?
I'm sorry?
Mid-trial, you can change your theory of the case mid-trial?
Well, it's not changing the theory of how it occurred. They're just changing the name of the crime from larceny by false pretense to larceny by purported transfer. They're not changing, not saying the defendant did something other than what they were always alleging in the opening statement and on summation. Nobody ever spoke about larceny by false pretenses. The words larceny by false pretenses were never uttered in the opening statement
Counsel?
or in the closing statement by either
Can
party.
you take an extra moment and speak to the forgery issue?
Yes, Your Honor. The claim of a forged instrument is unpreserved for appellate review. And this court, in Cunningham, in a footnote, left open the question of whether or not someone who has no relationship whatsoever with a corporation, who signs his or her own name to a corporate check, could be found guilty of having forged the document. And I think that the answer is yes, if you reach this question, but it's unpreserved. The answer is yes because, unlike representing another person, a corporation can only be represented by an agent. So it's the agent who now personifies the corporation, takes on the personality of the corporation, and so even if you sign your own name, it's a signature that's ostensibly the signature of the corporation, because the corporation can't sign its name. You can't find the signature saying HDFC. The signature would have to say somebody's name, so you wouldn't be able to forge a corporate signature at all.
If the name is yours on both sides of the ledger as the grantor and the grantee, I don't
I'm sorry, Your Honor. If you look, are you talking about for the forgery or for the deed?
forgery, yes.
No, if you look at Respondent's Appendix, page RA18, you'll see there's the signature on the bottom of the deed purporting to transfer from the first party to the second party, the property. It says Fernando Maldonado, owner. Then on page 821, where it has the transfer report, again, the HDFC can't sign its name, so the defendant is signing as the owner, and the owner goes, it's clear, sorry, wrong page, it's the owner is going for both when you read the whole
And
document.
it seems there was some confusion here over what the deed is. And the deed, I think, as you point out, is RA18, which is the
Correct.
actual quitclaim deed, which is signed by the defendant on behalf of the company, as opposed to that report, which I think is in the supplement, the appellant's appendix, which is only the report of the transfer, right?
Correct. So I think when it says there in witness thereof, it's never signed by the purchaser, because the purchaser is never going to be the one who's going to be able to be the witness. The seller is the one who might witness
The
it.
quitclaim deed is an actual transfer from HDFC to both as 50%
Correct.
owners, both
As
the
joint
individual
owners.
defendants, joint owners, owners in common or whatever, and the company and the
Correct.
corporation.
And ostensibly stating that Fernando Maldonado owned sufficient shares in HDFC to transfer from his corporate ownership to his personal ownership.
Thank you, Mr. Newbert. Mr. O'Neill?
Counsel, could you address this issue on, is it sufficient for conviction merely to charge purported transfer under Section 1 of the statute?
There is no case in this court where you can charge it, but you can't convict upon it. And the prosecution has tried to do prosecution by ambush here, Your Honors. And I must say, the people overcharged this case considerably. They should have charged offering a false instrument for filing. Now they're scrambling to find a theory that works. They're actually misstating the record, and I have to correct it. Page A810, and I quote, this is the court charging the jury. A person wrongfully obtains property from an owner when that person makes a false representation of past or existing fact while aware that the representation is false and obtains possession and title to the property as a result of the owner's reliance on such representation. That's the
And
first
that's
one.
when the note comes out and he recharges them essentially.
And he simply reads
Right.
obtains a purported transfer, which no one in the courtroom understood.
And that's
which is clear.
810.
That's correct.
Right.
But to the questions about your question, Your Honor, about the theory, the people said numerous times, 671, 784, 785, our exclusive theory here is reliance by false pretenses. To back away from that is prosecution by ambush. It's unfair, it's unbecoming, it's inappropriate. There was reliance here.
I think their argument, though, is not that we want to back away from it now, but we would have backed away from it then, right? So if you would have made this argument in the trial court, we could have switched gears then because we weren't locked into that in terms of that's a jury charge, but really doesn't affect how we've been presenting the case. But as I understand their argument, what they would have used is only Section 1 purported transfer.
There's absolutely no theory that the people could work on for these facts. Only false pretenses would work. So there's nowhere to back away to.
Is that because of your position that a purported transfer doesn't apply here?
No, Your Honor, because there's no reliance by the owner of the property, which is settled black letter
No,
law.
but if you could convict under subdivision 1 alone, then you don't need reliance.
No, it's still a theory of false pretenses. So the owner, how did you obtain the property when it's a building? You had to have the owner rely upon the false pretenses.
Your adversary, the people are saying that it doesn't have to be false pretenses. It's enough under subdivision 1 if there was a purported transfer by whatever means.
We have to then revisit that because a purported transfer means I sign in crayon a deed from myself to myself for someone's property and file it, and I've done a completed grand larceny. And that just cannot be, for all the reasons we talked about in the earlier session. Thank you, Your Honors.
Thank you.